Okay, good morning, everyone. We are going to take a vote this morning on H 293, an act relating to health equity data reporting and registry disclosure requirements. And I forwarded to you, and probably is on our website this morning, the changes that Katie had made. Katie, why don't you join us just for a brief moment, because it's not a lot of changes. But just to have you go through them. And yes, there is draft 1.2 on our website. Okay, good. Pretty straightforward.
Good morning, Katie McLean, Office of Legislative Counsel. We spoke about this bill last week and you requested 3 changes. They are highlighted in yellow, and that is to ensure that the agreements for sharing of data and databases are in writing. So the first of those changes is in section 1. This is our data responsive to health equity inquiries. Oh, that isn't in section 1, it's in section 2. Our cancer registry disclosure. So the language here is, however, before releasing confidential information, the commissioner shall obtain from such state registries, agencies, or researchers written assurances acceptable to the commissioner. And then in the next sentence, in the case of researchers, the commissioner shall also obtain written evidence of approval of an institutional review board or privacy board. And similarly with the ALS registry, the commissioner shall also first obtain written evidence of the approval of the institutional review board or privacy review board. And that's it.
And then Katie had pulled up for us the new Code of Federal Regulations citation, which includes both instances needing to be covered here. So we just wanted to be clear that we weren't, when we were striking out the first reference to 45 CFR Part 46, that we weren't losing something, and we are not. So yes, go ahead, Representative Steady.
My understanding, we're just doing this because the health department asked us to, right? Just to clean it up for them.
This is a request from the health department.
What I thought, so.
And essentially it is to enable the sharing of data among health departments, other health departments, as well as the researchers, because they're used for different purposes. So
I just wanted to make sure. That's what I thought.
anybody else have any other questions? Think you can take that down now, Katie. Anybody have any other questions before we take a vote?
Right out at the end of the hall, do you want me to go grab her?
Yes, that would be great. Just let her know we're voting on it now.
And were they fine with the written?
Pardon me?
Remember?
Yes, the written, yeah.
So everybody, okay.
Yeah.
I'm fine with it. I was just.
Yeah.
You know how I am with my vote. Got it.
Well set. Dan, you ready? Great. We're fast this morning, right? It's a short bill. I didn't know if you wanted to vote, I want to make sure.
But we're not voting this instant, right?
Yeah.
We're looking at it?
We did.
We did
Just now
already.
already. Do you have any questions? That's why we're in the, do you have any questions phase?
We're in the, we're not voting, we're in the, do you have any questions?
Well, no,
Okay.
we have finished our questions, but I'm opening it back up for you for any questions that you may have.
Okay, thank you. I don't have a question. I have a statement. Okay.
Yeah.
I don't think now is the time to dig deeper into the underlying issues. So, I'm going to support this relatively minor, relatively technical change, but I have really severe reservations about the current process and knowing what hospitals, tell patients. And it's one thing to be on a registry, even with your name on your medical information. It's not just your name and diagnosis. There's more to it that's placed. It's another thing for that information to be released to researchers anywhere in the country. And yes, they have to commit to maintaining the confidentiality, but it's still a different level in terms of a person's assumptions about where their confidential medical information goes. And I acknowledge I have direct personal history of being part of a major investigation panel for an IRB that utterly failed to protect the people at that university, that state university in Minnesota. So I have a bias of concern. And Vermont has one of the most lax because it's non-existent. We do not have any laws in Vermont that protect research, particularly around the area of who can give consent if the person who can't give consent on their own, they're unconscious or whatever. And we leave it, the IRBs can make decisions based on what the hospital says its policy is, rather than any kind of state law. And the fact that these things comply with HIPAA and comply with, federal regulations for what can be disclosed doesn't mean that as a matter of public policy, we necessarily agree with the disclosure. There's no question that the way they have it set up would comply with those various federal regulatory laws. So it's an issue I've had a concern about for a long time. It's an issue that, never makes it to a committee or a bill discussion because we have higher priorities. We tend to not react to something like this unless and until there's some horrible scandal or whatever. I think that's really unfortunate. It's kind of the issue is here simply because of a technical change. And I know that we can't take it on now. So I just wanted to say, why I have concerns about it, but I'm not going to that's not going to be the basis for me not supporting this at this point.
Thank you for that perspective, Anne. I appreciate when people bring if they acknowledge a bias, which I certainly personally have done in the past, and also how that can impact something that we're reviewing. So I appreciate that. Okay, are there any other questions, comments that anybody wants to make before we vote? Okay, clerk shall call the roll.
So the first thing we need to do, because this is a strike all, is we have to have a straw poll on accepting the amendment as presented.
Okay. This is now I remember why we're not going to do strike calls on little simple things.
It's a straw poll.
I know.
This is the written assurances line
Yes.
that we're adding.
That we're
right?
adding,
Correct.
yeah. Okay, so let's see, by a show of hands, we're voting on
Right.
the amendment,
To amend the bill is,
okay? So all those in favor, please raise your hand. Say aye, okay,
Aye.
everybody, that's an 11-0. And now we will vote on the bill as amended.
someone would like to make.
Oh, yeah, make a motion, thank you, sorry. About that part.
I move
Okay.
that we consider the bill as amended.
Version 2.1.2,
1.2.
yeah, it was reversed,
H
1.2.
293, 1.2.
We don't need a
We
second.
don't need.
Then I'll call the roll. Representative Bishop,
Yes.
Representative Cole.
Yes.
Representative Donahue,
Yes.
Representative Estes,
Yes.
Representative Garofano,
Yes.
Representative McGuire,
Yes.
Representative McGill,
Yes.
Representative Nielsen,
Yes.
Representative Noyes, yes. Representative Steady,
Yes.
Representative Wood,
Yes.
11-0-0.
Okay, and Representative Estes will be reporting the bill. And we gotta be there to support him on his first bill report.
I'm gonna set somebody up to start interrogating about research.
Katie.
I just watched this happen.
Yeah. And the reporter of the bill will say, I yield the floor to the representative from Northfield. Okay, all righty, thank you, folks. So this doesn't have to go to any other committee, so it will be on notice tomorrow and then on Friday, today's Wednesday, yes, then on Friday, it will go down. So, Zan, if you need any assistance, there are particular procedures you need to follow. Lori knows all about them. She's the,
She's gonna send that to me. She
you're
said.
okay.
Yeah.
And I just got the bill cleanly from Katie.
Katie, and you'll have a witness list and all that kind
Yeah.
of stuff.
Thanks very much.
And then we need to make note that Eric has used one of his remote votes.
Do
Okay,
I need to say that?
no, you do not, no. Okay, thank you all. And now, Ashley, nice to see you again. We are going to be getting some testimony, some thoughts from the Agency of Human Services about H92, an act relating to Human Services Board fair hearing proceedings. We had an interesting testimony yesterday. I don't know if you listened to it, but from Vermont Legal Aid on the disability side of things. We appreciate the fact that Joe Reinert has been in the room when we've had testimony, and he was actually able to also answer some questions for us. And so we're kind of an open book at this point in time. So welcome back, Ashley. And is there a document that you have?
I do not have a document for you.
Oh, okay.
That's what I was looking.
All righty. Then we will put our full attention on you and not reading the document.
Thank you so much for having me back again. Ashley Johns, Agency of Human Services staff attorney. After I was here last week, we've met with some departments and individuals about this fair hearings that go on at the Human Services Board and learned that this is a fairly broad process in terms of, and not that we didn't know that, but a fairly broad process in terms of the variety of hearings that go in front of the board. So any modifications that we would recommend, we would want time to analyze any unintended consequences to make sure that we were not putting ourselves in a position where either federal funding would be impacted for one department or some change would impact just a specific type of hearing, and the individuals bringing that hearing, so that we have a fair process for everyone that's coming in front of the board. Because of that, what we're recommending today is that the agency would be willing to submit a report to the committee by December 15th of 2025, detailing current processes within the AHS process and then in the Human Services Board as well. We can work with stakeholders that have testified in front of the committee, offer recommendations to either improve beneficiary experience, increase administrative efficiency, and then really outline how we can also uphold that fiduciary duty to maintaining those federal funds and then state funds that go into these programs as well.
Thank you, Ashley. I think honestly, it's along the lines of understanding some of the issues and the discussions that we've had in the last few days, understanding that while it may sound, at one level, very straightforward, recognizing the depth and breadth of all of the Agency of Human Services programs, all that have different rules, all that have different federal funding sources, all that have different community partners that are part of this process. I think it is important to understand how all of those things interrelate. And for instance, one of the things that we've been talking about is how do we enable the appellant. We heard yesterday data that the vast majority of people arrive at the Human Services Board without representation. So how do we enable the appellant's voice to be understood and heard from their perspective, while still recognizing that this is a quasi-judicial type process? The next level being a Supreme Court decision if you want to appeal it. So that the rules of evidence do apply. But when you say that to somebody who is emotionally tied into advocating on their own behalf or on the behalf of their family member, it's they don't really care about that. And that's, understood, I can understand that. They're trying to get a point across and sometimes feeling like they're not adequately being able to convey that information. And so, so we were saying like, well, what if we had a process where it just enabled the appellant to be able to say their piece, and then the department's attorney able to say their piece, and then, the hearing officer, judge, and ask questions. And really legal aid said, well, interesting concept. However, that would also mean that we couldn't object to something that the department was raising. And so that, of course, would be an unintended consequence of a process like that. And what we're really struggling with, I think, is before you get to the Human Services Board, and what does the Agency of Human Services do to facilitate an understanding of why decisions are made, what the next level is going to be like, and also recognizing that that's an awkward position because they could end up being adversaries at the board itself. And so you don't want there to be undue influence by a department to try to inhibit a person from exercising their right to file it further. But you also, in cases where there might be a clear jurisdictional issue, like the Human Services Board doesn't have jurisdiction on that, why put somebody through a process that is going to end up in them being very dissatisfied at some level as well. So we are kind of, we think that the process can be improved. I'm not sure exactly how we might accomplish that just yet. But we're going to take a look at some draft language at some point in time in the next day or, maybe today, that will help us maybe start to formulate and appreciate the offer to work with the departments. I think it's actually really important for AHS as a whole to work with the staff attorneys or the AAGs. And I don't know how, it seems to be different for each department. I think it's really important for perhaps some sensitivity training for some people about how to object in a way that doesn't feel as disempowering to the individuals who are there, who may not really understand that this is a quasi-judicial process. And even just saying that, and I have to say that Joe has been very open to feedback and open to how they could improve. I've forwarded some information or examples of what Green Mountain Self Advocates have done to make complex processes more understandable to people. I hope he takes us up on maybe contracting with them to try to do that for the Human Services Board. And I hope that AHS will work with all of the attorneys involved, including maybe the Attorney General's office, if you got assistant AGs involved, to think about how this process could be improved, not only from the appellant's perspective, but from the department's perspective. And I think in some cases with implementation of new changes in how programs are funded, with potential cuts coming down from the federal government, there's going to be a lot of appeals. I'm not sure that, current staffing levels will support the volume of appeals that may be coming their way. That might be something that needs to be considered at the AHS level.
Just to speak a little bit to what happens in departments. So every department is a little bit different because they're going to have different topics, but I know specifically DEVA, for example, does have an entire appellate department that will work with individuals before they ever have to get to the Human Services Board. So they're walking people through a process where if they can fix this problem and not have to have something go to the Human Services Board, we want to fix the problem before it gets to the Human Services Board, have that more adversarial procedure. So I know that they have that specific, there are other departments that have different levels of intervention prior as well, just depending on the type of hearing and the type of issue. But I know DEVA has a very large volume that comes in because we're talking about Medicaid beneficiaries. We're also talking about specific decisions on benefits.
Yeah.
So they have an actual department that deals with all of that. In terms of them also giving out like documentation or instruction, there is one really hard limit that we're going to run into, which is we can't give legal advice. So I don't know if there is a way to, something we had talked about internally, work with BLA, if they were able to have a document that could be shared. Like we can share that information from BLA, but we can't create something that contains legal advice, how to subpoena a witness, giving someone actual procedural advice on what to do once they're in a hearing. But it's certainly information that could be shared when we are sharing the rules of the board hearings and that procedure document that already goes out.
Yeah. Yeah. Go ahead.
Do you collect data currently by department and division? Given how there's so many within HS, there's so many different. So I'm just wondering, thinking about the feedback loop of, if they're getting similar appeals that are being overturned over and over again, like, is that data available by, we got some data from Joe, but that's kind of total. And when I was looking at data, I was wondering like what percentage of those are like related to Medicaid or housing or, because all the cases are very different. They're probably getting the length of time that is being worked on them is going to be very, very different depending on the type of case. So I just didn't know if that data existed.
I don't think in a way that is comprehensible as an entire agency, because each department keeps some data on their appeals processes. But that was one of the reasons we had recommended a report, is after talking to the departments, I think if we're comparing data, it makes sense to have the same data. Otherwise, what we're comparing is apples and oranges, and that doesn't really give us any functional information to work with. For example, I think DEVA is the one that I talked to quite a bit, but if DEVA has this whole process where they're getting people through a process without going to the Human Services Board, and then they only have, this certain number going to the Human Services Board, it would be really different if they have, 50% of their cases solved before they get there, and then they have different outcomes at the Human Services Board than someone who only has 25% of their cases solved before they get to the Human Services Board.
Would help the agency realize what could they replicate from departments that are maybe doing it well, that are preventing. I mean, the goal is to prevent the cases to go to the Human Services Board, right? To have a resolution, hopefully to the satisfaction of the individual. So if there are departments that are doing that well and are dealing with it at the department level where it's not being escalated, because it's, the more it gets escalated, obviously, the more resources are being used. So,
and I think no matter how well we do it, we will always have cases that go to the Human Services Board, because there will be times where someone wants a benefit or, something that just doesn't fit within the rules and regulations that we have. And one thing, that's still their right to appeal it. It's still their right to have that hearing, but just not something that we can grant.
Go ahead, Representative Cole, and then Representative Bishop.
Thank you. What timeline is the department envisioning for that kind of report?
We had hoped December 15th of 2025, so that way you would have something if you want to take it up next session.
Okay. Thank you. Yeah.
First, a thought, then a question. With respect to what a document may look like that outlines information for petitioners, I think there may be greater latitude than you were outlining with respect to what could be shared without still giving legal advice. For example, a subpoena, even explaining what a subpoena is and how it's utilized without taking that next step of, you may want to subpoena people, but, and whether that's done at the department or through Vermont Legal Aid, I'm not sure. I have a strong opinion at the moment, maybe in collaboration. But with respect to the report that is being proposed, As you might imagine, this committee may take some prerogative on what would be included in that report. But what might the department, in the conversations you've had already, what might you be able to share with us with respect to what you see would be included in the report?
I think one thing would be outlining the process for each department. So, and the different types of appeals, right? Because if you're talking about some departments, they're going to have more than one type of appeal going in front of the Human Services Board. Department of Children and Families, for example, is going to have both those hearings on abuse registry, and then also having those ESD hearings related to benefits that are being received through that department. So I think having that outline would be very helpful for everyone in terms of what the process is in each department, what that looks like, and then how these hearings ultimately work their way up to the Human Services Board. That would be one major piece. I think, and if we have recommendations based on that review about administrative efficiency, I know last time we were here, we had talked about there's departments within the state where we can talk about what that looks like from a process mapping perspective. And then also outlining the fiduciary pieces of this. So funding for departments, if there are issues with federal funding, kind of outlining that this specific type of appeal has to have this specific process attached to it because of those federal requirements. Those would be the big outline pieces. And then, depending on what we learn from stakeholders, talking to Vermont Legal Aid, talking to the Human Services Board, really getting an idea of, I know you mentioned, for example, the types of hearings that go up. So if the Human Services Board is saying, hey, we're seeing this type of hearing over and over again, that's something that we would want to look at internally in terms of gathering that data.
Mhm.
Is there, where might you envision the discussion we've had about plain language, increased or changes to documents to be more readily accessible, if you will, to the non-lawyer? Is that something that the agency could move on sooner, or do you think that's something you would also want to include in the report as to how that would be approached?
I think it would depend on the breadth of that ask, right? So if we're just talking about a document and looking through it to determine whether or not we think this meets a plain language, an individual who's receiving this can understand it, I think that's one thing. If we're talking about limiting what can be said in a hearing, I think it becomes much more nuanced because we're talking about, first of all, we're talking about controlling people and what they say, which is already going to be a question, but also then, moving them to that next level in court. There are going to be specific legal phrases that I'm certain are used by our AAGs to denote objections.
Yeah. Go ahead, Representative Donahue.
Yeah, it just seems to me that, the right legal terminology can be used, and that it would also be possible to have a plan where there's somebody who's clearly confused or concerned. If there was sort of an automatic, even if it was technically a mini recess to say, okay, we're going to stop and explain what happened, why you were interrupted, and what this means. And then you explain that, really sorry, we needed to interrupt you because the reason for an objection might be that something that's not allowed to be in evidence. So, a little explanatory in the moment where something like that happens, where a person wouldn't be expected to have all of a sudden, objection or motion to, and then back on track. But I don't think that would hurt the appeal process or so forth, just to take that little step back and explain when something happens.
I wonder if explaining objections up front would be an easier ask for your hearing officers, because if we pause in each location to say, this is what happened, here's why, I worry you're going to have hearing officers that teeter over that line into giving legal advice, especially if you have lawyers. But a more broad, even if it's included in, and again, I think maybe working with VLA on a document that explains this is what an objection is, this is what these definitions are, either without giving any legal advice or allowing VLA to craft something that gives them legal advice might, and I say this without having asked VLA, I should say. So, but I wonder if that's something that a collaboration might be able to get people more information before they're put in that position.
And my response would be, I don't think that would help.
Okay.
Because that's not the way people's brains work. They're reading something and even remembering it. So even if it was something briefer where there's an objection and the hearing officer has a little script that just says, remember, there's a there's a paper you got that explains what is happening and what this means. They're not gonna be skewing anything if they just, okay?
Remind people
A
about what
reminder,
this means.
because from the perception of that person, no matter what they've gotten in writing, they're being cut off, they're being, this is out of control. And just a reminder, folks, this is something that's normal in the process. Check your handout about what this means.
Representative Noyes.
Thank you. Just, this makes me think about small claims court and how there's a lot of people representing themselves. And I wondered what they do and if they have any, handouts, or how do they, deal with, this type of a hearing? Because it often is individuals representing themselves in small claims. Might be worth reaching out to them and seeing if there's any parallels that you might be able to utilize.
I don't have any experience in small claims court in Vermont. I do have experience in small claims court in Ohio, which is where I moved from. And I will tell you that based on my reading of these hearings and those, like, small claims court can be very contentious. So like, even if they are explaining, I think that particular forum can just get very heated. And I would hope that's what we're trying to avoid for human services board hearings.
I just thought.
I thought, yeah. And I think that we also need to be clear about, so there's kind of, two entities that I think our committee is trying to impact. So the Human Services Board itself and its operations, and then the attorneys representing the various departments in AHS and how they approach the case and how the experience. We're trying to impact in a more positive way the experience of the individual, the appellant, who is there, mostly the vast majority of whom are representing themselves. And so I just think that's important for us to be thinking about, because we realize the Human Service Board is an independent entity. And so they will have certain things that they will be responsible for. And I appreciate the fact that AHS is recognizing that maybe we need to sit down with everybody, and look at the breadth of what it is that we bring or our clients bring to the Human Services Board. And how are the ways that we can approach that? And are there necessary differences in certain programs? And then how we might be able to figure out a way that appellants receive assistance, maybe not from the department, but how they receive assistance in a way that is not, going against any of the, the roles that people have to have. So we'll see if we can figure that out. Yeah, go ahead.
Thank you. So with the report that you're envisioning, do you envision that AHS is going to be collaborating with the specific stakeholders in developing the report? And who are you envisioning are the stakeholders?
I think it makes sense to collaborate. I mean, I'm not sure that any of them would have any insight into the processes as they exist at AHS. I think that's probably something we'll have to do on our own. But in terms of determining what's where people see issues or what is coming up in front of the board, I think we're going to have to collaborate, one, with the board itself to get an idea of their scope of specifically mentioning that they get the same types of hearings. Be important to know that. I think VLA is an important collaborator just in terms of, especially if we're looking at plain language, legal language, can they give legal advice? Is there any mechanism for VLA to assist clients here? And I know sometimes they're at the Human Services Board, but I think it's fairly rare. So I think working with them just to have that better broad understanding would be great. And then open to other stakeholders that are identified as we work through it.
Thank you. Go ahead, Representative Donahue.
So based on what Representative Noyes said, I did a quick lookup, and I'll send the link to folks. But if you want to model, you go to the small claims roadmap, get oriented and get organized. And you can just see from here, the picture on the top, there's even the little picture for people. It's, it's illustrated. There's a video that's 2 minutes, 47 seconds long. It's done by VermontLawHelp.org.
Oh, okay.
And, this looks like exactly what,
Oh, that's a Vermont edition.
yeah, it's a Vermont,
Yeah.
starting a small claims case in Vermont, getting organized, getting oriented and organized, roadmap, and then each of the steps, preparing for the hearing, et cetera. It's like, yeah, it'd be a perfect model for something that would be great. And then if it was added into that,
The context.
remember, this is what, remember, look at the sheet you got. To remember why we're doing this,
Yeah.
why that lawyer just said, okay.
I think that it is, given the volume of cases that the Human Services Board is seeing, it's, it's not a couple of dozen, it's hundreds of cases. I think that we need to up our game in terms of being, and I'm pretending that Joe is sitting next to me. We need to up our game in terms of how to make this an accessible format for individuals. And, that's a good resource, for us to refer them to. And I think, I like the concept of a video because people can they can watch it over and over again. But some people prefer to see something in writing and they're, so I
And you
think
can
there's
print
multiple-
off the writing or have it available in court.
Exactly.
Print it
Yeah.
off to have for people.
And I know that we can't afford at this point in time to, offer legal representation to everybody who goes to the Human Services Board. I get that. But even one of the legal aid attorneys said, like, when they used to be held in person, we might be representing one out of, 5 cases that were before the Human Services Board, but we could sit out in the waiting area and say like, oh, offer that what you just said earlier, of just a little bit of advice, and they're not necessarily representing them, but saying, this is what you might hear in there, and this is how you could handle that kind of thing. So we appreciate AHS being willing to kind of take a deeper dive and to be thinking about this in a way, because as I said, I think that given where we are, both at the federal and state level right now, I think you're probably going to be seeing a higher volume of appeals. And, if there are ways that we can meet people's expectations and not have them all go to the Human Services Board, that would be great. Because I don't think people like to go to the Human Services Board. They would prefer to have their dispute handled at the lowest possible level. So this also involves community partners, in many of the departments. So I have to think about their relationship in this process as well. And I don't know if AHS has done a rule review of the various programs that all end up at the Human Services Board to see if there is consistency in the rules, that look at Human Services Board as the, final administrative process. But I know that it appears in a bunch of rules, and we're about to add another one to it in H91. So I think it's important for us to have some consistency across departments and programs for what that language says. That will make it easier on the Human Services Board as well, too. So thank you very much for coming back today and for thinking about this at the AHS level. And we appreciate your information and willingness to help us think about this.
Absolutely. Do you mind if I had one comment just
No.
before I go? I was just thinking the AAGs would be distressed if I did not comment. If we're talking about anything that has to do with their abilities to say certain things or object, we do have to also look at the attorney ethics rules, because they're going to have some ethics rules around providing the best, I forget what the actual wording is, but assistance, zealous advocacy. Thank you. And I just would want to make sure that whatever is being looked at doesn't interfere with their ethical obligations to be able to represent.
Oh, of course.
Oh, right.
So just putting that out there for consideration.
Yes, yeah.
Thank you.
And I realize that the AAGs also kind of have, they have 2 avenues of reporting as well.
Yes.
At department level and then at the Attorney General's level. So I get that too. Okay, thank you so much. Ashley. Appreciate it.
That's for the word assist.
Yeah, look at it. Yeah.
It's like the whole way. It's, you all ought to skim through that.
I will.
Small claims
Did you
court.
send the link to it?
I sent the link. I sent the link.
Okay.
Yeah.
Yeah, I mean, that just briefly looking over Ann's shoulder here, I mean, it's like, that's the kind of stuff that we're talking about.
Exactly.
Yeah,
what they need.
simple.
Yep.
Yeah. Okay, that's great. Do we have Ashley Berliner online or in the waiting room?
She's not here to send.
Oh, I looked up there and I saw that we were 10 minutes late. We're not 10 minutes late. I need to learn how to figure out how to read a clock. Okay. All right, so why don't we have Lori post that H92 draft and we'll take a look through it and you can describe the process you and Katie kind of went through.
Sure.
So for committee members, I've asked as a learning experience, I've asked the vice chair to lead us through the H92 process in terms of markup and consideration. And since this was a short form bill, it involved actually putting words to paper and based upon the feedback that we've gotten and the testimony we've gotten, and of course it will continue to evolve. But we have a first stab at some language. So, and we have some time between now and when Ashley's here, the other Ashley. So Lori is posting that to our website now.
Thank you, Madam Chair. So wow.
Oh, the website, I went to my email. Can I go back? Sorry.
Are you doing?
We're
You're confused. Sorry, I thought you were like breaking and I could.
No, we're not breaking. We're just waiting for it to be posted. That's all.
It's today. Also,
I don't know what it's all.
it will be.
So while Lori is posting the draft that we have, I'll just share a little bit about the process as Madam Chair referenced. We had a short form, so Katie and I had to draft the bill, which was exciting to do. So Katie and I reviewed my notes and just kind of put some concepts out based on what we heard from the testimony up to this morning. So the feedback from Ashley has not been incorporated in this. It's really kind of thinking about this from that process improvement lens and collaboration lens and trying to figure out what systems can we put in place to make the process easier to understand, more human-centered, and then also more efficient and identify where the gaps are and where the kind of areas are that could use improvement, both for the board and the appellant side. So what you're looking at again is,
It's already here.
you know,
We
it
will be
should-
looking at it.
Yeah.
It's here.
It's there now.
I see
It
it.
is there.
Yeah, you gotta refresh
you
here.
should have-
Oh, I have to refresh.
Yeah.
Okay. I was waiting. I was just.
There it is. Yeah.
Okay, let me go get it.
Go from a half a page to 10 pages in
10
one fell
pages,
swoop.
yeah.
Wow, that's crazy. Okay,
So what we did was looked at the underlying statute, which is the Human Services Board. And Katie also took this opportunity to kind of clean up some of the language that existed and improve upon, do some of those technical changes that we have an opportunity to do since we're looking at this. We're looking at making changes. So, and to be completely honest, I haven't looked at this draft that closely yet. I looked at the last draft that she sent me. So the first section in 3090A, they're just technical changes. And going through hearings, again, just technical changes. And so the first major changes start on page 4. Section B1, and yes, Brenda?
Ray, I have a question. On page 1, well, I didn't get very far, because I was reading, where it says on 17, the board shall hold it meetings and by the chair.
Yeah.
Could you put a period there and take out the on and say the chair's own initiative? So you don't have chair and chair in the one sentence?
So editing usually deals with the grammatical
Yeah.
issues. We typically in committee don't do that.
Oh, I didn't know that.
Yeah.
And I'm a big
It will draft,
grammatical
and then
person.
it will go to whole editing department.
Okay.
Where
Oh, they do that. Okay. Thanks. Okay. Okay. Page
Going
4.
back to page 4. So, a lot of the testimony we heard was about improving the material that the appellants receive and making sure that they're in plain language. So we thought that making sure that the appellants receive plain language summary of the hearing process 10 days before the scheduled hearing makes sense. And we included things that should be included in that summary.
Can I ask a question
Sure.
before, I'm back with Brenda, not quite that far back, but in the beginning of section 2. If we can, ask AHS to look at A, and covered programs.
I'm sorry, tell me again what section?
Section 2, 3091.
What
I'm a little far behind.
It's on page 3,
Okay.
halfway down on page 3. I suspect that needs to be updated, given that it hasn't been updated in quite a while. And I'm pretty sure that it's not only the WIC program or a licensee at the health department. Substance use services, for instance,
Right.
would be covered. So if the department could take a look at that, and since we are going to be doing some language changes, if you could get back to us about that in the next day or so, that would be great. I'll be honest, my preference is, or the preference of the committee would be, instead of listing out potential programs like it does with BDH, I think it can be general and just list the departments. And then each program will have its own rules that says whether it can or cannot go. But think about how that might be worded, if you wouldn't mind.
So yeah, in case there are changes, then we're not like.
Having to go
needing
back and
yeah.
update this every
So
time.
have it more high level.
Thank you.
Yeah. Okay. All right, so back to, at least 10 days prior. So page 4, so those are the things that we were thinking of ensuring. And, as we're hearing the testimony, I think, and the way I'm thinking about this, I want to make sure that we somehow incorporate the guidance document that's going to the appellant to be updated and used. So I think this section needs some work based on what we've heard this morning. And, hearing from the department this morning or from the agency this morning, I wonder what we can do now, kind of to Doug's point earlier, as far as the existing documentation needs to be updated. We also need to have a process for the agency to kind of come up with future changes that are more robust about the whole, broader process.
So is B1, that's all new? I mean, it's underlined,
Yes.
so that's a whole new
That's a whole new
section.
section,
Okay.
yes.
I mean, I think it's good to have that new section in there. I think you're right in terms of what we might want
What
to
we
put
might
in.
want to put in there,
Yeah.
yeah, yeah.
I think that's good. And then, so, yeah, why don't you keep going and walk us
Okay.
through the other things? Yeah.
So, so those are under B1, all the items that we want. And then, on line 17 through 19, including, the rules shall provide for reasonable notice to parties, including a requirement to identify the legal issue that the board or hearing officers anticipated to decide. So that's really to help the appellant understand what it is that the board is taking up and looking at. So they have a clear understanding of if there are other issues that they're dissatisfied with, that the board's view may be very narrow.
Mhm.
So clearly identifying that for the appellant. And then page 5 is all technical changes. 6 is all technical changes. And then page 8, lines 18 through 21. So this is where we were talking about just collaboration and making sure that there's some formal convening between all the stakeholders and how that had been happening informally in certain areas. We heard from the different departments and the different witnesses that that had been helpful when it had happened. So we wanted to ensure that we incorporate that more formally and ask that they do that. And again, that's something that now can be incorporated in this report. But for me, it's important to ensure that we kind of compel these stakeholders to come together and regularly meet to identify, to look at the process and the procedure and the data and identify patterns and things that could be improved on. Go ahead.
Yeah, just, it says, and advocates regularly appearing before the board. I'm just wondering, I just want to make sure they're brought into that process. I'm
Mhm.
wondering how that's decided or, you know, if we need to prescribe that.
Where are you, Julie?
What?
What page are you?
Oh, we're on page. Yeah,
Line
bottom. Yeah,
18 and
It's like
19.
the board-
Page 8?
yeah, the agency and any departments and advocates regularly appearing before the board.
I just want to see groups as opposed to, that implies
Yeah.
it could be individual advocacy. And I think what
Yeah.
we're meaning is disability.
And I,
rights and-
yeah, and I want to make sure that they're, you know, aware it's happening and have the opportunity to participate.
Yeah, it's almost, there needs to be one group, the board or the agency has to be responsible for convening
Convening,
a group
yeah.
of these people, because
Yeah.
otherwise it's like the advocates have to help convene it.
Yeah, see,
Yeah.
Yeah.
Yeah, that'd be this.
I agree.
Okay.
I mean, what you're kind of laying out here in statute is a continuous quality improvement process,
Exactly.
essentially.
That came to me at the end of the testimony, that it seems to me rather than just fixing something that's wrong, or we're hearing is wrong, and especially with cases with the what we're expecting to come toward us next, it seems like this is a great planning opportunity.
Yep.
For continuous
And I
quality
envision,
improvement.
you know, if we decide to incorporate what the agency recommended this morning and having them come back to us with a report
Exactly.
after
Yeah.
kind of getting together and doing like one big process improvement plan, right? Then, once they have that, then to have regular convening so they can continue evaluating what the changes that were made and implemented. Are they making improvements? Are people having better experiences? Are the
Right.
rates changing? Are the outcomes changing? And if not, then we have a process in place to continue to improve the process.
Yeah.
I kind of think quarterly might be too often.
Too often?
Yeah,
Yeah, we weren't sure about
Yeah.
that.
I
Maybe
just
it's
didn't,
annually.
I just kind
biannually.
of think
Yeah.
like, you know, maybe
That's up to
twice a year, or once a year. or
Semi-annually,
something.
right.
I was thinking, yeah, same, twice a year.
And then I thought it was important to kind of call out the chief performance office within the state government, because that's kind of the responsibility. I know AHS has their own person, and then there's a statewide office that handles and can provide support around this work. And then we thought having a report that kind of lays out the number of cases and the cases that were resolved, before the hearing, number of hearings, decided in favor of the appellant, and cases that were in favor of the agency. And really here is, the feedback loop. What are some of the patterns that they're noticing, and how are they communicating back to the department? So, and yeah, like the rules can be updated or addressed, so we are not having so many of these going to the.
I have just just because I don't quite fully understand this yet, just a question. So let's say that I make a request for a fair hearing. Before I ever get to the Fair Hearing Board, there's an opportunity for a department to address the issue. Is that aspect, that part of my request under the auspices of the Fair Hearing Board, so we would see that kind of information in a report? Or is that just department proceedings? And then we would only hear about things that got finally all the way to the Fair Hearing Board. You see what I'm saying?
Yeah, and I think what we heard is that the departments aren't keeping each department is
Has
keeping
different-
their data differently.
Yeah.
They're gathering data differently around what they are resolving or addressing at the department level.
It seems.
So I'm sorry, but I do think, given what we heard this morning, I would like to expand this to
Yeah.
kind of include in the report that comes back, recommendations on how to gather that departmental level data and how to ensure that that's being reviewed as well as the human services, because they both matter, right?
Right, well, it seems to me that our responsibility is to look at this entire process. From the moment a person enters a
Right.
fair hearing request, that suddenly is something we need to be concerned about. So we need to know what happens before it ever gets to the Fair Hearing Board as well. And that could probably be included.
It'd be helpful for us to all look at like the latest report.
That's what I'm looking at.
Oh, I have it pulled up.
Yeah,
To see kind of like what it looks like
Yeah.
currently and what feels like it might be missing or.
the question that I had was because in the draft, it all appears as though it's a new section, but
To everyone.
It's all
Yeah.
there, alright, that would be nice to provide this.
yeah, 3090 section E, 3 VSA, section 3090 paragraph E. So I don't know what it says in that section, but it says pursuant to that, here's the summary of appeals and human service board. So there is statute that requires them to
exists.
submit something already.
Okay.
I don't know if it's as specific as what you've outlined here. But, and so you can, if you're wanting to look at it, you can look under, Joe, on Thursday, March 27th. You can find the report, or you can look under reports.
I also just emailed the link, so.
Or you can get it on email that Jubilee just sent you. I'll give you.
I heard it ding. There it is. So we click on that.
There it is, yep.
There it is. Okay.
So it was, I mean, there's a lot of information here. I think, not so much in terms of analysis, it's just kind of
Reporting data.
data.
Yeah.
And it's unclear to me, I can't even tell after I read the opening paragraph, whether it includes the cases that are settled, like they're brought to the Human Services Board and then they are withdrawn. Because theoretically they've been settled, but we don't know the outcomes of those. And he said he wasn't sure. They presumed that when it's withdrawn, that there is a favorable outcome to the individual,
Right, but
we
they
don't
don't
know
really
that.
know that.
Right.
And I think those are things that we can ask the agency and their work in developing this report and recommendations
Yeah.
on making recommendations on how to improve this report and include things that would help us understand how cases got resolved, where they originated from, like which department did they come from? How did they get resolved? Did they get withdrawn? Was the withdrawal because of a satisfaction or was it because the people just gave up?
It actually, and it may be different by department, but what I'm
Yeah.
looking, the one I'm looking at right now for economic service, Three Squares, Vermont, affirmed. These are where there's a number, dismissed for lack of jurisdiction, remanded to the department, reversed, Vermont Supreme Court appeal, Vermont Supreme Court decision, withdrawn before hearing, dash, department's favor, withdrawn before hearing, outcome unknown,
What page are you on?
withdrawn before hearing, page 8, petitioner's favor, withdrawn in department's favor, withdrawn in petitioner's favor, withdrawn outcome unknown. Now, what's interesting is the two largest categories are withdrawn outcome unknown, 40,
Yeah.
and withdrawn before hearing outcome unknown. But it does seem, it has all those, at least for this one, I don't know if they have that. That may be what a department provides, so I don't know if it's that detailed on.
So I mean, I think
Yeah,
one,
Gail,
it's
yeah.
important for us to take a look at what the existing report has before we decide what it is that we should add to or take away from or request, but that's differently. So I'm going to encourage us maybe to spend a little bit of time with, in committee, I don't know if maybe with Joe to go through the report. He referenced it and included it in his testimony, but we didn't really review it. I mean, there's a lot of information here. You can tell just by virtue of the fact that they break it out by program. Okay, so they hear all sorts of different, types of appeals. It's not, it's quite varied, and it is, the withdrawn outcome unknown.
We need to dig deeper.
We need
into
to,
that.
have a little bit more information about that.
So, yeah, this really goes to one of my pet peeves, but, and it's not pointing fingers except to all of us
Yeah.
as a legislature. There are an awful lot of reports that we request that's when they become cumulative, it's a huge burden on Agency of Human Services.
Yes.
And then we don't read them. And that's a big drain on, so we shouldn't ask for things that we're not going to read. There is that are we still doing that sunset review GovOps each year?
I haven't,
I haven't seen them in a few years.
Been
Used to be this,
At the beginning,
list of
actually.
reports and saying,
yeah,
unless a committee objects, we're going to delete this one because they've been doing it for X number of years.
I got a spreadsheet at the beginning of last biennium.
Okay.
Where I identified reports that we could do away with, but,
Yep.
I haven't this biennium yet. I mean, however it is that you best, can review this, I'm going to encourage each member to review
Mhm.
this report, and then we'll come back to this section to see what, if anything's missing, or what we might want, maybe further clarification, or if there's things that, we don't have to have
Right.
anymore. That's also important to know.
And
It
just
would
to
be
be clear,
helpful.
I did not read this either. Not like I do.
That's our first question.
No, no. For the Advisory Council on Child Poverty and
Right.
Strengthening Families, I was reading lots of reports this summer. And there was one report where the intro was like, the guiding information we're supposed to use for this report is no longer connected, but here's my best stab at collecting this data.
Yeah.
It was just really highlighted how overzealous with the reports and and not really following up.
Well,
weekly.
and I think that's why, you've seen a trend, I guess I would say, I say that cautiously, but in asking for presentations as opposed to reports.
Yes.
So that was one that we just did on syringe services.
Yep.
That bill asked for a presentation. But it's incumbent upon us to follow up and make sure that we get those presentations. But I think we do need to be sort of aware of the various reports that we ask for, and what are we going to use them for,
Also, in this case, I think, getting the agency to do a report to figure out and recommend on what changes should happen that we can then take up next year is different than asking for an annual report.
Yes.
Because if we're not going to do anything with the data, I mean, internally, the agency should be looking at this data. And maybe that's something we say, that we want the agency to have a process improvement plan based on the data and based on what is happening with programs, but not require various agencies and departments to produce this annual report that is cumbersome and administratively burdensome. That
So just to not take us down that
Yeah.
sort of further
Rabbit hole,
down
yeah.
that rabbit hole about reports. We certainly can, we'll have some time, a little closer to the end of the session, we can go and look at all the reports in under our jurisdiction, and we can decide honestly if we can dismiss the need to submit them, but we're not going to do that
That
right now.
Yeah.
No, and looking at your language under K there, this one that lists
Yeah.
these things. This is not a report where it says send to the General Assembly. It says Human Service Board, send to the agencies and departments.
Yeah.
To
That's for
identify.
internal,
For
yeah.
internal, which I think would be, clearly incredibly useful, based on some of the estimate.
Describe there just before the effective date, you talked about annually, the legal counsel representing a department shall participate in training on interacting with pro se appellants.
So that was really, as a result of given so many of the individuals going before the board don't have representation, and Vermont Legal Aid doesn't have the resources to provide representation for everyone who wants it. We thought it would be really important to have some kind of required training for the attorneys that represent the departments, to know how to interact with people who don't have attorneys or don't have any idea of what this kind of quasi-legal, setting is like. So, kind of to Anne's point, to minimize some of that, intimidating interaction, or at least help people understand what the process will be like. So we just thought that would be really helpful for the attorneys to have that.
So how to, this is essentially how to zealously represent your client, the department, while at the same time understanding the emotional nature of the interaction that the appellant is bringing in their person.
Madam Chair, may I add to that point? So we've been talking at times, having a few chuckles about zealous advocacy, a term of art that came before our committee. And it is part of both the national ABA's, American Bar Association's model of professional conduct, and what is included in the Vermont professional conduct rules. And just to read the sentence in the preamble, it says, these principles include the lawyer's obligation zealously to protect and pursue a client's legitimate interests within the bounds of the law, while maintaining a professional, courteous, and civil attitude toward all persons involved in the legal system. So I think we're getting to this point of the courteous, civil attitude, but also beyond that, just to enhance the understanding, because I don't think a lot of legal training goes into working with pro se litigants, or you're going head to head against a fellow attorney. That's the nature of the training, and for many attorneys, their experience. So I think there's opportunity through this to build upon what's already in rules and professional conduct. And this is not to chastise or make assertions that people are acting outside of the rules of professional conduct, but to enhance on what's already there.
Right, because they may be being very courteous and respectful, but that doesn't translate into somebody without an attorney and their experience of it, because being courteously told, well, I need to make objections when I need to,
Yeah.
doesn't help that person's.
I think being oops, sorry.
No, go ahead.
Okay. I think it never hurts any of us to have additional training in trauma-informed practices, in understanding how we might be adding to somebody's trauma in the way that we interact with them, and tips about how to avoid that. And I've never been a lawyer, or never been to any of the educational opportunities that lawyers or lawyer wannabes have. And maybe they receive some sort of training about that, but I don't think it would hurt on, you know, those individuals who are involved in the human services field to, you know, have that trauma-informed training about how to zealously represent your client at the same time that you are being informed by the, really, it's a traumatic event for somebody to be at the Human Services Board, period. Yeah.
What I was gonna say is that the last words in the sentence that you read said within the legal system.
Right.
And I don't think an appellant that is like trying to advocate for their child's, you know, disability services, consider themselves as part of the legal system. Right? So I think that's whereas an attorney reading that will. And that distinction of the people that are coming before the board aren't really part, you know, especially most of those who are not being represented, they're not envisioning themselves as part of the legal system. So it's a different type of interaction that they're having.
You know what I would like? I'd like to hear testimony from the attorneys that are on the Human Services Board to see what they think about this. So can I make a suggestion?
That's what Joe is.
Yeah.
No, he's the only one.
Well, there's Joe and two other ones right
But he's-
now.
I'd like to hear from the other two too. Or can I contact them personally? I'd like to hear, because I think we're overstepping, telling somebody they have to get additional training. I feel like
It's
we're
not
over.
for the Human Services Board. This is for the attorneys
I know.
that
See,
represent.
that's why I said
the
I'd like to talk to them,
Oh, we did talk to them already.
but I would like to.
Well,
Am
go ahead.
I allowed to? Can I get the numbers and the information?
You can look.
I just think we're overstepping there a little bit.
Yeah, and I guess what I would encourage you to do is Ashley represents the Agency of Human Services. And so maybe you can talk with Ashley and Brendan about that offline.
Yeah, because I think we're overstepping.
Brenda?
That would be the AGs that represent the agency in hearings.
Yes.
Well, who's gonna pay for it, you know, and that type of information. I mean, you're on, these people might have homes and on a budget and do they have to pay for this out of their own pockets?
No.
See, I would like to hear.
It would be part of their, essentially their professional development. And so we're just saying that if you might recall the testimony we received from the couple that
I
talked
did.
about, okay, and how traumatized they felt by the process. And so what we're trying to do is to figure out a way to reduce that trauma.
No, I totally understand what you're saying and I totally understand it, but I think we're overstepping telling a lawyer they have to get training once a year. So I guess I would like to hear from them personally, so I can get that information from you. Thank you.
Thanks.
I think
Thanks.
Yeah, no, I mean, you said a lot. I was just thinking we require training of lots of various organizations. You mentioned Trauma Informed Care, which is what I was thinking. Our housing agencies, we require they do fair housing training annually, and this just feels like in line. I mean, there's some where I'm required and hired by the federal government to do like mental health first aid and trauma informed care. So it felt in line to
Just
me.
to be fair, I know this.
Just a second.
For that.
You call
So,
on people, so I'm just.
Oh, okay, it was
Yeah.
Anne and then Doug. Sorry.
So I was gonna back to, before we sort of got a little bit on the side, I was gonna wonder whether we should also include hearing officers as
Yeah.
getting participate in training. And I also wanted to remind or point out, sometimes in statute, in some cases, like we did with we did a few years back with the medical board folks with all doctors, and they were not at all happy at being told they had to have added
That's what I'm
training.
saying.
But yes, but in that case, we were actually requiring number of hours and credits and so forth. This is pretty open in terms of, we're talking about, actually a lot of it is done online, talking about a 1 hour refresher once a year. This is not a burdensome requirement for people who are in that specific job. We're not doing something requiring all lawyers like we did with all doctors or whatever. It's just if you're in this job, and it really, it becomes, as I responsibility of the department to have that available, to have that, whatever it is, that little module that.
No, I've been on so many boards. I understand. I just think we're overstepping.
Yeah, they're all employed. So this is part of their employment time. It's not something new they have to do, or they have to pay for training, or they have to go on their own time. This would be part of their paid time.
If I would just add to this point, and unless I'm mistaken and other lawyers can correct me, when I last practiced, there was still a requirement every 2 years to fulfill a certain number of continuing legal educations
I knew you were gonna say.
credits. So if it rose to that level, they could seek the ability to have this count towards the attorney's hours they are required to finish. And then
That's what
and if
I'm
it
saying.
doesn't, it's still just, whatever it may be, an hour, 2 hours, 3 hours of time, even if it's outside of the required CLEs every 2 years.
What? I asked, Ashley, can I ask you a clarifying
Got
question?
lost.
So we heard, excuse me, sorry. We heard from the different department attorneys, and when Jennifer, so I think there's a different structure for each department as far as certain departments have the assistant attorney generals representing them, and then certain ones have staff attorneys. Is that accurate?
Certain departments have staff attorneys. I don't think any staff attorneys represent the departments in front of the Human Services Board. I think it's all AAGs, but I can verify that.
Okay, I thought Stuart said that they have staff attorneys at Dale.
He might have had, he had a staff attorney that handled appeals, but I don't know if that person went in front of the Human Services Board or if those were internal appeals like to a commissioner. So I can find out.
On the, before it got.
Oh,
to the
before I
humans.
got, okay.
Yeah. I was just looking for Jennifer. She's not on our witness list.
And can we get the refresher on the AAGs? What is their relationship in terms of structure versus AHS? Are they contracted to or assigned to but don't report to?
Yes,
If I
they are
recall,
assigned
yeah.
to departments to represent them, but they still report to the AGO.
So it's more.
Okay. Great. I think what we're gonna do now is take a break before our next witness. So this has been helpful, I'm sure, to our lead person assisting with the drafting on this, and appreciate AHS being here.
Thank you.
And we'll take another stab at this. And I think it might be helpful to have somebody from the Attorney General's office, just because they represent, they kind of do the oversight of that. So we'll get, this is, are you listening to this one, Madam?
I am.
Representative Steady? We're going to have somebody from the Attorney General's office, which will be able to answer your question. So you will have to